Is that what the judge said? That's the problem I have. When he says that the reason the defendants gave wasn't sufficient under the law, what is he saying? Was he saying that it was pretextual, which would be a fact determination, not a determination based on what the law is?
Well, I suppose, Your Honor, I mean, we could put that context into any other abuse of discretion situation. The court isn't required to give reasons for a lot of its rulings, and we search the record for that, and what we have is here for this court is a record.
And so our determination is that it was pretextual? I mean, is that ultimately the conclusion we have to say, is that he didn't abuse his discretion in saying that the reasons given by the defendant were pretextual?
I think that's the inquiry. I mean, we're looking to determine whether he made a mistake.
What in the record would suggest that it was pretextual?
The fact that he is trying to strike one of two black people left on the jury.
But after he's been arguing that we need to keep black people on the jury.
And you're entitled to give weight to that, and I don't blame you as you're looking for it. I mean, again, you know, I can't say that I looked at this issue and went, man, this is a dead bang winner for the state because of what's there, but what we have to consider, and that's why I'm encouraging you to look at the abuse of discretion standard and give some credence at least that this person was actually in the room. I mean, we are presuming that, or presuming away, I suppose, every benefit the court or the large amount of discretion that we give to trial courts by suggesting that somehow he has worked. I think the theme here is that the court was biased against this entire process, and his sole goal was to make sure that this person got death. And I don't think the record bears that out whatsoever.
I don't think anybody's arguing that, counsel.
Well, I think that's the theme of their brief, Your Honor. That he was slighted against them. He made for-cause challenges against their position, an inordinate amount, unfairly, is what they're arguing. And they're doing the same thing here with regard to this Batson challenge.
I read much of the argument to be more that Judge Clark was focused on trying to ensure that there was a somewhat racially diverse jury, and that he may have put more emphasis on that than he should have.
Well, that's part of their argument, but the other part is that the judge, and maybe bias is not a great word, maybe the judge committed misconduct because he didn't apply the right test. That's part of their argument as well.
And that's an abuse of discretion.
And that's not.
That would be an abuse of discretion if he applied the wrong test. I can't argue with that.
Applying the wrong legal standard. I thought
absolutely.
That was my understanding, that was the
in part
main argument.
And so I think to that extent his motive could have been good, but it just could have backfired.
Oh, I'm sorry. Can you say that first part again?
I think his motive might have been good. I mean, his motive to try to retain some diversity on the jury.
Quite possibly. I don't know. I don't know that was his reason. I think we're reading that into that. I suppose that's my point.
But that's our difficulty too, is we just don't know. And as I kind of pointed out in the other situation, a lot of times when we don't know, when we don't have the factual findings that allow us as an appellate court to make an informed review, what we do is we remand and ask the court to make those findings so that we then know what the judge's thought process was. But we now really can't do that, can we? Given the situation we have. It
would be difficult.
Yeah. So how do we deal with that?
And that's why I submit. I suppose I'm aware of any case, Your Honor, that would say that when we stand up to make a Batson challenge, and our reason is that there are two there, and they're taking one away, and we believe it's because, inherently, because they're a minority. I'm at a loss to understand why that isn't enough if the court believes it. We did not see, as believable as we may think the attorney's reasons are, they're undoubtedly race neutral. I mean, we can't argue that part.
Why were there only two left? The state had struck, by that point, an African American.
That is true.
I'm having a little trouble saying that the prosecutor can strike African Americans down to the place where there's only two, and when the defense tries to strike one, say, "Oh, that's discriminatory." When you say your reason was there were only two left, that's because you had, or your office had struck other Africans Americans, or at least one. Correct?
Again,
Well, is that factually correct?
that is factually correct, Your Honor. Again, I think my difficulty with this is the person who was in charge of assessing the credibility of an argument like that, or even theirs that said, how could we possibly have been motivated by race? I'm black, he's black. We tried to prevent you from taking a black off. Okay, so we had two parties, each of which would presume to be arguing the same point against one another, and we trusted somebody to make that decision, and that decision was made by Judge Clark.
We have to presume he made that decision. What he verbalized was making the decision with regard to his belief as to the adequacy of the race-neutral reasons. That's what he verbalized. To get to where you are, we have to presume the judge internally made that third step because he didn't verbalize it.
What I hear the court saying is that there, I mean, if the law at the time was the judge didn't have to say any particular words, this court is now looking to change that law.
What we're looking at is the words he did say. And the words he did say were legally incorrect because the court does not make a determination of whether the race-neutral reasons are adequate reasons, are adequate under the law. It determines whether they are, in fact, race-neutral, and then it moves on to the third step.
Of course, and you understand my argument is that language was not an indication, because in order to do that, you would have to disregard the fact that moments before that, the judge said he knew what the test was based on Bolden. Again, I am not saying that this is the clearest record in the world on this. However, it's hard for me to ignore that the people in the room weren't questioning whether the judge was making the right, using the right test to make the strike. I mean, they never complained about it. And it's on a cold record alone that everybody is now attacking that. And I understand that part of the discomfort is the fact that there isn't any verbalization from him, but and perhaps, you know, two wrongs don't make a right, but this isn't the first time in this court's history that we've bypassed that and looked at the record itself, because we allow appellate counsel to come in, review the record, and give us situations where there are other jurors who shared the same characteristics. And this court would look at that and say, you know what? The court did abuse its discretion. So, Justice Lukert, I mean, if you're asking for how do you determine whether there's an abuse when there's an absence of any other evidence? And here we don't have that absence. Perhaps if there had been not had those three people that was struck, maybe the court wouldn't have that basis. But I don't know how we presume that the court was actually blind to everything that was going on. And I know that, you know, we're here potentially to decide whether the court was required to say anything. I would submit that this court has never held that. There isn't any court that has held that I know of any substance.
Could I move you to the, if we disagree and decide that it was an abuse of discretion, what's the remedy? And I'll tell you, I'm having a little problem saying that if they were passed for cause, then it's harmless. Otherwise, there's no way that we could ever enforce the right to peremptories.
Is this related to the question that Justice Rosen was asking?
Well, if we disagree with you, what are we going to do with this? We've already determined that it's not practical to remand it.
Well, the state's position, I mean, would be primarily as to whether we maintain the convictions and the death penalty, would be that if this isn't a constitutional issue, Your Honor, the United States Supreme Court quite clearly has said that the right to peremptory challenges is not a constitutional issue. And as Justice Breyer has pointed out, the states are free to formulate their own test. I would submit that we don't need to do that in a vacuum. As indicated in our brief, I'm sorry, and the statute escapes me, but there's a statute that indicates what the rights are, and the rights are to 12 peremptory challenges. It doesn't indicate how or when. The reality is in any jury trial is that you're never guaranteed 12 people you like, but you're entitled to 12 impartial. You may want to strike every one that's left on the jury, and they want you to presume in this case. And
You're saying it wasn't error. It's not a trial error if the court erroneously disallows a peremptory strike, because you just have no right to which ones you have 12 strikes, but you don't get to choose.
I think that you have to make an additional showing of actual prejudice of some sort. They're asking you,
And that's where I'm getting to, and we talked about that earlier. How do you show prejudice? And what's the test for prejudice? That's part of what we're struggling with, I think.
admittedly, I can understand why. But I think that's why I'd like to take you to it's almost like we're trying to answer the question before we're trying to determine the root or the basis that would allow you to even get to the question. Here, I would submit that in order to determine if there is any remedy that needs to be employed, you need to determine what that right is. And we would submit that the right is to 12 strikes, and they received it because they had the ability to challenge for cause. And granted, in this case, they're making an argument that kind of clouds the issue. It's not like a singular issue where they tried to make a peremptory strike against somebody they didn't challenge for cause. Here they try to challenge him for cause and for peremptory. But if we start with that starting point is that they get 12 as long as the person has been passed for cause, then there isn't a situation where you can presume prejudice, which I think is almost like the structural. To me, that's related to structural error. Why is it that we reverse cases automatically on structural error? It's because we are incapable of measuring the prejudice, and that's what they're asking you here. And I would submit that in order to find that, you have to find prejudice. Here, the statute doesn't give you that ability, and neither does the Constitution. And as to the for-cause aspect of it, I think that's a different question. I would submit that you would go to the for-cause issue first when you're deciding this. Was that a good denial of the for-cause strike? I don't think you can answer the peremptory without first answering that question. If the starting point is that the for-cause strike was good, or the decision not to allow it was good, then your starting point for this issue has changed.
I'm smiling because I'm recalling some cases where this court has said, well, there's no prejudice because the defendant could have used his peremptory challenge to get rid of the juror that the for-cause challenge was denied. And now you're saying, well, that's there's
If the for-cause has
Not on point, Your Honor. If that issue had been raised, perhaps the argument would have been different. As you know, we deal with the arguments as we take them.
I understand, but you're saying you really don't have a right. He wouldn't have had a right under the statute to strike that particular person, because you're saying that the right to strike 12 is
That's
numerical, not
qualitative.
That's correct.
Yeah.
That's my argument.
Yeah.
And again, it's something that this court is, if this issue turns on that, that's great, and that's my argument on that. I hope that answers Justice Rosen's question, and I think Justice Biles was coming in on that too. And I suppose, if we don't win that part, the next question or answer would be that we would look to have, because he was being challenged as a death-qualified juror, we would ask that you uphold the convictions, and if you need to reverse the death sentence, then that would be the other remedy, I suppose, that would be,
And that would be based on the observations that the reasons given was specific to the death penalty and his demeanor towards that and nothing else, and therefore the guilt phase would have nothing to do with the death penalty.
absolutely.
So that's your basis for that.
Yes.
As a last resort, I would suspect.
Yes, I would prefer to have them all, everything.
That would be consistent with the reasons given for the peremptory challenge as well by defense counsel. When they stated their race-neutral reasons, they talked about that this particular juror was impaired on the mitigation factors, which of course wouldn't enter into it.
Right. Just one observation, I think. I'm not saying that this controls the issue or anything of that nature, but, in this case, WB was one of 3 jurors that they're complaining about on the for-cause issue. DR and DGE are the other 2. Part of the makeup of the jury, the defendant used 8 of 12 peremptory strikes to strike some of the jurors who weren't even challenged for cause. So some of the people that they viewed, if believed, that these were the worst of the worst because you made a for-cause strike on them, I believe 4, I don't want to misstate that, but there was a number in there, around 4, that were still on the jury that weren't even challenged by the jury. It could have been 5.
4 of the 27 the state talks about who were passed for cause by both sides.
Well, I'm talking about that actually made it to the jury. There's some that weren't
Right,
challenged.
right, but I think, if I'm remembering the numbers.
I don't want to misstate that.
There's a lot of numbers flying back
I know,
and
that's
forth, but.
part of my problem as I
But
stand
as I
here.
recall, the state took the position in its briefs, there were 27 who were passed for cause by both sides. And you're saying that at least 4 of those ended up serving on the jury.
Right, there would have been 60, and out of those 60, there were 27 that everybody agreed were passed for cause.
Right.
That's your question. That's what
Yeah.
you're commenting, right?
And they used, excuse me, I think I misstated. So they ended up using peremptories to strike 4 of those 27 who were passed for cause.
Your Honor, if I can
Sure.
get this right, can I?
Yeah, I'd like you to get it right. I'd like to understand it.
I believe our assertion on that, Your Honor, is at least in Reginald's case, on page 230 of Reginald's brief, it says, as to defendant's argument that 3 of the 4 jurors at issue remained on the panel because he was required to use peremptory challenges to remove other jurors who should have been removed for cause, Reginald discusses the use of 8 of his 12 peremptory challenges and 5 of Jonathan's 12 peremptory challenges. No mention is made of why Reginald did not use his other 4 peremptory challenges on the jurors in question, and I think there's that would mean that there were 7.
Okay, thank you.
But again, that doesn't necessarily control the issue, but this strike on WB as well was it was the 12th strike. So there were 11 more people. You can either read it into it or not read it into it, but there are 11 more people they chose to strike for some other reason that seemed to be more important to them.
That's not true. When you're going through your strikes, you leave the ones to the end that you think the state might possibly strike.
That would be one way to look at it, and I'm not, like I said, I'm not saying that my version's correct, but that's one way we can look at it as we argue about this. Obviously, we're at a point where we're discussing this and having some differences of opinion, but to me that this comes down to the abuse of discretion standard.
I want to change subjects
Thank
on
you.
you, which I'm sure you
Yeah,
want to do
ready,
at this point.
ready.
I need to move you over to the Walenta killing.
Okay.
Really, what's the evidence against Jonathan Carr on the felony murder?
On the Walenta killing? It's tied to the fact that he had the light-colored Honda-type car, which ended up being a Toyota car, was used. Jonathan and Reginald were known to be together frequently, and in fact, that night there was testimony that they were seen together. There's also evidence regarding the gun being the same gun used that they'd been in possession of. He had been in possession of at various times.
When you say the same one used, you mean in the other two instances?
In the other two instances.
Okay.
Admittedly, it's not quite as strong as it is with Reginald because we don't have the identification type, and that's subject to argument as well.
Can I confirm my understanding of one fact related to this question?
Okay.
As I recall it, the law enforcement officer who handled the photo ID with Ms. Olenta, it was the same person who testified that she saw the car waiting and pulling away as the shooter ran away. I mean, that seemed like the only piece of evidence that actually put a second person involved. Was that car leaving as he was running toward it or running away?
Anna Kelly is one of the witnesses. Are you referring to?
No, actually, I'm talking about law enforcement. I thought it was Reynolds or something like that. I'm sure.
Oh,
Sorry,
whether
the name
that was
escapes.
the only evidence tying?
Yeah, that put a second perpetrator at that crime, so if we've got trouble with, if we've got Crawford trouble with the ID, do we also have Crawford trouble with that piece of evidence, putting a second person there, a second perpetrator?
If that was the only evidence.
I don't think the neighbor talked about that. I think it was just
that
Crawford.
evidence also came in through Detective Landwehr, unobjected, I believe.
Okay, thanks.
I can verify that in just a
So it would
moment.
still be Ms. Walenta talking to Detective Landwehr, correct? So we'd still have a Crawford issue potentially?
Except
If you only have law enforcement talking about a second perpetrator, that's what I'm trying to get at, then you've got the same testimonial hearsay problem you have potentially. the ID.
That's correct, except, again, we are submitting that he has to make an objection, even under the rules of evidence, and I do want to talk about that point, because I don't think that the automatic review rule would apply to that count. 214627, the automatic review rule, quite clearly limits this more liberal review to convictions that also have the death sentence with it. So even though we have the same trial, I'm not sure how we graft this more open review rule to that felony murder itself.
But the problem is you're using that incident also for some of the other charges, aren't you? You're using the two prior charges to sort of set up the capital cases.
Not
I mean,
not directly, Your Honor.
Well,
not directly.
let me-
indirectly.
Let me just ask it in the abstract. Where there are capital and non-capital counts in the same trial,
Right.
how do you divorce the use of evidence on the non-capital from the capital counts? I know the jury said, well, you have to decide each count on its own, but the evidence bleeds over. To me, it seems like that's really impossible to compartmentalize that evidence.
I suppose the best answer I could give to that is the evidence of those other crimes were not used directly to convict in the capital case. It was more of a almost like chain of custody type argument. How do we know? They are tied to the gun, for instance. And to answer your question directly, I can't say that there was absolutely no purpose, but it wasn't direct evidence of that nature. If defense counsel wanted to limit that or something, I don't see how this rule, just in general, I think my opposition to the notion that this statute on liberal appeal issues negates the necessity to object when there could be some reason for it. Admittedly, in this case, I don't know what that would be, but I don't know. I hate to speculate about why an attorney who is open and liberally objected on numerous occasions chooses not to in some other occasions. Without knowing why he didn't object, I don't know how we presume that the entry of that evidence was error. Even though we might struggle to determine at this point what that is, I don't know why on appeal that we need to jump to that conclusion. We do have other avenues to reach that in 1507. I think the limit on this new issue or unlitigated issue being raised on appeal or discussed on doesn't necessarily require this court to reach finality on any issue, but it does require this court to at least look at it and make a determination if there's a factual basis to reach the ruling itself. They can't just raise some ruling. I would submit that this court surely can appreciate that. If there's an insufficient factual basis to support a legal issue, as it always has, says, look, we're not going to take this up for the first time on appeal. Creating a situational advantage to the state on any issue can't be tolerated in the name of bringing the issue up when there's other facts that could be involved. And what we have here is I don't know what those other facts are.
I'm sorry, I'm not following that bit of argument, which,
Okay, well, let's just
Well,
take...
it might be. I mean, Crawford, if memory serves me correct, is a 2004 case, isn't it?
Yes.
And so what we have here is a trial in 2000 or 2001. I don't know that the Crawford issue would have been raised as it's so crystallized in 2004 for us from that point forward. But back then, maybe it wasn't so crystal clear about what type of evidence comes in.
And that would be true. Well, I mean, I think the simplest example would be, why do we not take up every claim of ineffective assistance of counsel that's raised on appeal? It's because we don't know why counsel did what they did.
right, we need facts.
We need
developed in the
facts, whether we do a Van Cleve or whatever it may be.
And so I'm just trying to understand how this is relating to what we were talking about a moment ago. So you're saying that that's,
Well, I'll tell you
okay,
why.
will you connect them up for me? Thank you.
I'm not necessarily saying on this issue. I just launched off on a tangent regarding many of the issues in this case.
That's
I
reassuring
would
to me at
encourage
this
this court, while I have my time, to, at every point that they're trying to raise a new issue that we don't get to, I just want to be clear that I don't think that that's a reason that we launch into every issue. I think this court can make a determination as to whether there's something else lurking there and that this issue can be raised sometime in the future.
Oh, I see what you're saying. Okay,
With
thank you.
regard to this issue in particular, though, again, my submission is that I don't know why counsel didn't object. And for this court to somehow determine that counsel erred by not objecting and that it's automatically going to take up this issue, I think that requires this court to presume that counsel made a mistake, and that determination has not been made.
What is the purpose then of the statute that says we can consider unassigned error? I believe is the language.
Well, for I'll try. I actually had this thought out at one point in time before I started working on both cases together. Now that's blurred, but there are times in the two briefs that an issue's been raised and we haven't objected when it's brought up for the first time on appeal. And if it's something that's clear on the record. Let's take, for instance, if there's a stipulation or something that's been made, and for some reason, appellate counsel decides that they want to.
Well, I don't really care what counsel does. The statute says the court can consider unassigned error.
Okay.
And so what is the purpose of that allows us to look at the record and identify errors that have not been identified?
My example would remain the same, except that let's just take appellate counsel out of the mix. If this court reviews something and it's the legal propriety of a jury instructions, in fact, we do that all the time. So we determine if it's clearly erroneous. If this court reviews the record and determines that there's some insufficient instruction, this court doesn't need to rely on anything else to determine that issue necessarily. It just so happens that, if that's the case and there is no dispute about the facts that would support a particular legal ruling by this court for the first time on appeal, then I don't see that would be the purpose of that statute. But I don't think that statute stands for the proposition that you can take up every issue and make a ruling on that issue. I mean, that doesn't make any sense to me when the factual basis isn't established. And we may disagree that in this case, regarding the failure to object, maybe you may find that there isn't any basis he could possibly have. I would just submit my argument is that there's no basis to make that ruling.
Mr. Loudon?
Yes, ma'am.
This morning, we visited with your colleague from the DA's office about the charges on which the defendants have said there was a legal insufficiency. The rape charges as to the victim men.
The cause.
Right, and the cause?
The cause elements causing so-and-so.
Yes, we talked about those three charges that had to do with the men as victims of rape.
Okay.
And we also talked about the digital penetration count. And Ms. Parker and Justice Johnson had a fairly extended colloquy on that. I just wanted to give you an opportunity to address those issues if you wanted to. How are those charges legally sufficient?
And if I recall the conversation correctly, and it seemed like maybe Justice Johnson didn't get an answer to his question. Is that correct, Your Honor?
I just wanted to give you another opportunity to
If
talk
I'm
about
thinking about the same one,
the innocent agent
where the innocent
discussion.
agent could be a victim,
Innocent
is that
agent.
right?
Right, right. Who's the innocent agent? Let's start there. Let's start at the building blocks. In the rape situation, where there's a male victim, and he is the victim because that's clearly identified, I think, in the charge. Is that person also the innocent agent, or is the female the innocent agent? I'm just trying to understand.
I'm not trying to obstruct or skirt this. Are we presuming?
Well,
there's a number of claims regarding that instruction, so that's why I'm pausing.
Just trying to focus on the legal sufficiency of a charge of rape when the perpetrator is the person who forces, through threat of force or fear, forces a man to engage in sex with a woman, and the man is listed as the victim.
Okay, well,
it's important.
Are we going off the instructions that were given? Is that the
well? Actually, I was talking about the charges, the way the charge is constructed. Maybe you can help out here.
Yeah, the defendant is charged with raping a male. Okay, that's what it says. The defendant, who is a male, is charged with raping a male.
Okay.
That's what it says. Okay, and we were trying to figure out how that can happen. And the argument in the brief was, the doctrine of innocent agent. And the complaint says that the male committed an act of sexual intercourse with the female. That's what it says, is the basis of the charge. And so the innocent agent doctrine says the defendant can only be guilty under that doctrine if the defendant's acts would make that defendant a principal if he had done the acts. Okay? And so how I can see that if it's charged that the defendant raped the female, utilizing or forcing the male, but I don't understand how that results in a rape of the male, the way it's worded.
And your question to me is a pure sufficiency question.
It's a legal question. How can this
Okay.
defendant be legally
Okay.
charged with raping this male under the way it's worded?
Okay.
Using the male to rape himself, basically is what it says.
Well, first of all, I think that you're focusing on only part of what was charged, because the other part of that charge would be whoever that male is was forced to have intercourse without consent under force or fear. You're making an argument based on the construction of the sentence itself, and I'm not saying that because basically you're saying the charge is that Jonathan caused male to have intercourse with female, right? And you would not be asking me this question if it said Jonathan caused female to have intercourse with this male.
I'd have a different question.
Yeah, but that's the root of your issue. I would submit, Your Honor, that I don't know that there's a distinction when the entire document is looked at between the two ways that you say. It's clear through the consent or force or fear aspect that he is the victim. Whether he's in the first position or the second position in the cause aspect of that, he still remains part of the sexual intercourse. Whether he's the victim or the innocent agent, he is caused to do this.
Is he both? I mean, that's what I was trying to figure out. Can the innocent agent be the victim too?
Well,
That's really what you're.
can I parallel, if I might, I'll parallel this to something else, and maybe this brings clarity, maybe it confuses the issue. If I have somebody that I want to kill, and I have a gun, I can pretty much shoot them myself or not shoot them. Instead of making that choice, I allow the victim to make the choice. I hand them some poison pills or something and say, you can either die by the pill or I can shoot you in the head and kill you. The victim decides to take the pill and die. In that instance, innocent agent and
victim. Okay.
Why is this any different? I don't know. And again, I don't know that would
Is
be
it
my...
the definition of rape that makes it different?
Quite frankly, I think part of the... Again,
Or maybe
that's
it
why I was
doesn't.
asking so many questions to start with.
Yeah.
This is charged in a way that we are not accustomed to seeing, with the cause language. And part of my argument on that, and that's why I don't agree that we necessarily charge male as the innocent agent in the construction of the sentence itself. But I'm also saying I don't know that it matters based upon the murder theory there.
My second question, if you're using the female as the innocent agent, how do you get around the Doyen case that says that I think that's the case, that said that in order to apply that principle, the defendant would have had to be found guilty as a principal if he'd have committed the same acts, and that's physically impossible for him to have committed the same acts.
As the female.
As the innocent.
Are you talking
as
about
the case says that for a person to be found guilty for the acts of an innocent agent, the person must have been amenable to being found guilty as the principal if he or she had done the acts that the innocent agent did. Now, that's our case law.
That's true.
And how does that apply? How do you factor that into this scenario? Part of the reason we have it a little different is that we have males and we have females, and rape is defined in terms of the female anatomy.
Right, so your question goes to how can the defendant who has a penis put his place himself in the place of the woman who has the vagina? Is what you're asking.
Under our
Some
law,
words.
I mean,
Um, excuse me, may I just? Ca- Thank you, Your Honor. Counsel's reminded me, I mean, the definition of sexual intercourse doesn't, it's the penetration of a female sex organ by any object or whatnot. I think from a technical standpoint, I mean, I don't have an answer to your scenario because obviously the anatomical differences I can't account for between the two. But
well, and we have the rule of lenity, and we have the rule of vagueness, that a person needs to be given fair warning of what's criminal conduct. And I'm just having trouble how anyone would understand this theory of prosecution and your theory that you're giving today based on how the complaint's worded.
okay, I guess in that respect, I would argue that the rule of lenity doesn't necessarily apply here, because we're not looking at, for instance, a construction of statute or something. I think the actions of the parties up to this point in time indicate
I think we
there was
have
no
to,
confusion regarding how this was going to be. They just didn't agree with that it was a crime.
I think we need to construe the rape statute to see if the conduct that you're alleging would fit within that definition of the crime, just like we would have to construe the murder statute to determine whether aiding and abetting a suicide in your scenario was also murder.
Well, if we, the rape statute indicates rape is sexual intercourse, and it goes on. It doesn't use the words cause, engaged, or whatever, or had, or whatnot. Again, I can't help but think that the wording that we used has caused some of the confusion, but would we be here today if we had just said Jonathan had intercourse with male victim, and then the defense, asked for a bill of particulars or however, or maybe we put into the instruction to wit caused such and such to have sex with such and such. And again, that's why I'm asking, if this is going to the sufficiency of the cause issue, if we can assert in a rape whether one person be caused to have another intercourse with somebody else, my discussion is completely different, and I guess that's the source of my confusion. And I'm standing for you. I'm not trying to avoid your question. I would very much like to answer that question. I just don't see how, when we're asserting that somebody was forced to have intercourse against their will, that this issue turns on the rule of lenity and whether somebody had a penis or whether somebody had a vagina, when it's irrelevant to the ultimate conclusion. Did Reginald force one of the males to have intercourse against his will by force or fear? And I think that as a notice instrument, that was satisfied in this case.
That's not the question.
Okay.
The question is, if that happened, and we're assuming that did happen, does that
what happened, Your Honor?
constitute the crime of rape?
If what happened?
Just what you
I said?
described.
Yes. And again, that goes to their claim that because aggravated criminal sodomy and other sexual offenses have the cause language. Is this going to what you're talking about, Your Honor, as far as if it is a crime in fact, or you're just speaking on how it was actually charged with the innocent agent and victim?
Both. And you're saying that causation, if you cause someone else to do something, then you have committed that crime on the person you caused to do it. That's what you're saying.
Yes.
Okay.
Because there is the innocent agent in subsection 3 of the aiding and abetting statute. I mean, I don't know how we avoid this, or how we get around the application of this. We basically have to find, in any instance, with the murder one being a prime example, that because every statute that doesn't talk about cause, there are more that don't talk about cause than the ones that do. So everyone that doesn't talk about it, that we can't have a situation where somebody hides behind the actions of an innocent agent to commit the crime. I mean, that is an untenable position, I think, and I don't know how we get there.
No, I think that's you make an excellent
Yeah.
point. And if the charge was using that innocent agent to rape the female, that's the scenario that's anticipated by the innocent agent doctrine, that he utilized the male to rape the female.
Okay.
But what you're using it for is he forced the male to engage in this act, and therefore he raped the male. Now that's what you're charging.
Your Honor, I don't want to misspeak, but if the instruction in this case, and I don't recall what the information or complaint that you're talking about is, but to reach the conclusion you've reached would be to disregard the other portion of that, Your Honor. The statute merely says that, and perhaps your hang-up, maybe if I think about it this way, maybe I can understand your question. You're saying that there's no indication that HG was forced to have intercourse with one of these males. Okay, if that's not it.
No, we're not saying that.
If that's,
It's okay. I think we've kind of gotten to impasse, and probably it's best to move on.
Right.
Did you have anything further on that? I don't mean to cut you off, but
The only other thing I had in that regard is I noticed that it was charged in the alternative, rape or aggravated sodomy, and it referred back to some instructions. Was there any allegations of aggravated sodomy?
with regard to the males, Your Honor?
Anyone?
With regard to,
there are 3 counts of acts.
there were 3 regarding the male and 1 with the female. Yes,
Okay.
with the female, there was an aggravated criminal sodomy.
Okay.
With regard to the males, no, there was not. If in that vein, I know where you're going with that. State v. Wright. If that's what that's designed to ferret out, I would ask this court to. I know Justice Moritz authored a concurring opinion in a case last year. George Lowell Brown asked that the members of this court who did not join in that concurrence join in that concurrence in this instance. It's basically a situation where there was absolutely no allegation or evidence that the men were victim of aggravated criminal sodomy. The fact that that crime was included in the instruction itself that went to the jury is essentially, I don't want to say harmless error, that's not what Griffin found, but it's a situation where there's no reasonable probability if we presume that the jury followed the instructions. And I think that's a recurring theme here is we have to presume the jury followed the instructions, that there's any basis to question whether that was the underlying sexual offense. There is no question. That couldn't have been the underlying sexual offense with regard to the capital murders of the males.
Counsel, I see you're well out of time. Would you like 60 seconds to wrap up, or do you think you've made your points?
Yes, I would, Your Honor. Thank you. With regard to Jonathan, the evidence is overwhelming in this case. I don't want to use this as a complete fallback position and say that no matter what happened in this case, that's not my first argument, that, we can do whatever we want. There can be as much error in this case as we want, and this harmless error cures it. I think that it does, but my primary argument is that in this case, the allegations of error are not founded. And to the extent that they are, I think there's a difference between looking at error, for instance, the reversal of the multiplicity arguments those don't factor into a cumulative error analysis to determine whether somebody's received a fair trial. I would ask this court to look closely at those issues to determine what truly went into the calculus there. But I do think that the overwhelming evidence, no matter when you retry this case, if you retry this case, again, the outcome will be the same because I think the evidence was that strong here. So,
Do we have any further questions of counsel?
Yeah, I need to clarify. Were you saying that with respect to cumulative error, that if there was error found and it was remedied, like reversing the convictions on the multiplicity, then that is not part of the equation for finding cumulative error? Is that what you're saying?
Yes, Your Honor, because it didn't affect other parts of the trial, we would submit.
If they're discrete, solvable problems on appeal.
Absolutely, yes.
Any further questions? Thank you,
Thank you for
counsel.
your time.
As I announced earlier, at this time, the court will be in recess for 15 minutes.